Welcome back to Pedaling Squares through a mammal's life, where we talk about all things cycling and endurance sports through a master's athlete's perspective. Welcome to episode 7, and I should say welcome back because it's a continuation of episode 6. We ended that segment with a discussion of impeding under Ohio law, and we're going to pick that interview up with a discussion of a seminal case that Steve worked on behalf of a gentleman by the name of Steve Seltz, which not only set forth some important precedent for Ohio cyclists, but it actually changed Ohio law. So join me. Fire up your trainer, fire up your treadmill, and enjoy the remainder of our interview with Steve Magas, the Ohio bike lawyer. Thanks. Seltzer case in a second here. Your Seltz. I added Seltzer to his name. Yeah, I want to talk about Steve Seltz in a second here. But there's, as I'm talking out loud, or I'm thinking, that's another one of those friction points in the law where taking the lane is the safest thing to do, but you're in friction with, not in conflict with, but in friction with this idea that you need to ride as far right as is practicable, right? So let's just observe that friction point. We're not going to resolve it in this podcast, but if you are taking the lane or riding in some portion in the roadway to maintain your right of way, you're almost always going to be slower moving than vehicular traffic behind you. So you're going to get into this situation where you are literally impeding traffic. But you also may be exposed or not to a charge of a traffic charge of impeding vehicular traffic behind you. So how does all that play out for an Ohio cyclist? And you know this firsthand from the Steve Seltz case, and give the viewers a little bit of benefit, because poor Steve was going uphill. It wasn't even like he was on some flat roadway.
Well, Steve was what I would call a transportation cyclist. He didn't own a car. He rode everywhere, rode to work every day, and every day he rode through Trotwood on, I want to say it's State Route 48, but it's like at that point, a 5-lane, 2 lanes in each direction with a turn lane, pretty busy, fast moving road. And there is a light, he's at the light changes, and now he's going uphill. And the testimony from the police officer was he was going 18 miles an hour when she pulled him over. And she pulled him over for impeding traffic because she said there were cars lined up behind him that couldn't go by him, even though there was a lane next to him that they could use.
Lane to his left.
They charged him lane to his left that was available. And they charged him with impeding traffic. And somehow, I don't remember how I ended up being involved in it, other than I got a call about this. And I said, yeah, I'll do it. I'll do it pro bono. Which means for free for those out there who didn't take Latin in 11th grade. And what I ended up doing was working with the Ohio Bicycle Federation. And every time I filed something, I would send it to OBF and we'd post it online. And if I got something from the other side, we'd post that online. And then we'd send it out in these different bicycle forums, and I'd let people comment on it and give me suggestions or whatever. It was sort of an interactive lesson in Steve's reality there. And so one of the things we ended up arguing, and I'm trying to find the definition here now, is what is it when I look at that law? What is it that can't be impeded? Well, it's traffic. All right, well, that's fine. What is traffic? And it turns out that the word traffic is defined in the revised code. And let me find it here. But basically, it is defined in a way that includes bicycles. So, a bicyclist is not impeding traffic. A bicyclist is part of the definition of traffic, and your path can't be impeded. And what I argued to the court was that impeding traffic means somebody who is intentionally going so slow as to prevent the normal flow of traffic from proceeding. And for a bicyclist going 17 miles an hour uphill, I told the court, look, I don't think he should get a ticket. He should get a medal, because that was a pretty good feat. It was certainly a reasonable traffic speed for a cyclist. And the court disagreed. The court said, gee, I don't know why anyone would want to ride a bike on that road, and she found him guilty. And so we decided to appeal the case to the Second Appellate District, which is a court of appeals. It's in Dayton. And it turns out there's 5 judges who are on that court, 3 of which were going to hear our case. And we didn't know which 3 were going to be sitting there until you walk into the oral argument. And I asked a friend of mine who had clerked in that court, and I said, what are these 5 judges like? And she said, well, 2 of them are going to hate you. They're not going to like your case. They're not going to reverse the trial court. And 2 of them are pretty outdoorsy guys who are probably going to be okay with your case, laid to your rider. And one of them is sort of in the middle. And so when we show up for oral argument, we file our briefs, we show up for oral argument, and here's Mr. Bad Guy, Mr. Good Guy, and Mr. Undecided. And so we spent our 15 minutes, pushing Mr. Undecided. We ended up winning a 2-1 reversal of the trial court. And the argument is here, traffic means pedestrians, ridden or herded animals, vehicles, streetcars, trackless trolleys, and other devices, either singly or together, while using for purposes of travel any highway or private road open to public travel. So that's what traffic is. You're not allowed to impede people who are on herded animals. I mean, that's part of the definition of traffic. Vehicles, and under the Ohio Revised Code, a bicycle is a vehicle. So a bicycle is part of the definition of traffic. Pedestrians can be traffic. If you're walking, on the road, you are traffic. It's a very broad and the argument was it's a very broad and colorful piece of fabric. It's not just cars and trucks and buses. It's got many different colors and shades, including, people in Amish buggies are part of traffic, and pedestrians and bikes and farm equipment going 8 or 9 miles an hour on a 55-mile-an-hour road. That's all part of traffic. So the court agreed, and in the Steve's case, the court held that as long as he was going at a reasonable pace for a bike rider, he was not impeding traffic. And then that was 2000. In 2006, it's hard to believe that was 16 years ago already. When we rewrote this bill for bicycling, we changed the impeding traffic law, and we added a provision that says, in essence, when you're analyzing this, you have to look at the vehicle, and as long as the vehicle is going at a reasonable speed for that vehicle, it's not. So
that almost invites.
We won.
Yeah, you won. You won.
Yeah,
that was a journey. That was a journey up into the Court of Appeals and come back down and get things straightened out.
Probably 18 months, and the city of Trotwood got cards and letters and emails from all over the world. I mean, this case was talked about in Ireland and Iceland and other places around the world where people were on these bicycle law forums, and we threw it out to anybody. If you have a comment on my brief, send it to me, and we may be incorporating it. So it was fun. Yeah. But the key phrase was, we are traffic. There's a whole website now, wearetraffic.com, that as part of the Savvy Cycling.
And that's that's the benefit.
Training.
One of the benefits of Steve's case is that, what's the old adage? Bad facts make bad law. Well, this is the inverse of that. Good facts make good law. You have an experienced cyclist riding responsibly, and it helps that he was a pretty fit guy, that he's hustling up the hill at 17 miles an hour, so you don't get the collective eye roll and I've done it, where you're only climbing at 5 miles an hour
Right.
because the grade is so high. People don't have any sense of perspective if they're not cyclists. You've got a guy that's fit, a commuter, responsible cyclist, knows the laws, applies them just right in an environment where everybody can pass the son of a gun in the available left lane, right?
Yeah. Now, here's the downside of that case is there is a throwaway line in the majority opinion that says if he had been charged under the A section 451155 for not riding as far right as practicable, the facts would have supported that argument. But that's not what they charged him with. Now, had they charged him with that, we would have made other arguments. We would have brought in an expert. I brought in an expert in this case who would have said, Steve was behaving as a proper cyclist, a reasonable cyclist who's going at a reasonable speed for a cyclist, and the prosecutor basically agreed to all of those things, so we didn't have to put the expert on. But so we had an expert to testify about the impeding. If he had been charged under, had him testify that his lane position was safe and reasonable and all that sort of thing, but we didn't have to do that. So
yeah, and that's one of the practical realities of representing cyclists. I'll get to that in our lightning round of cases, or excuse me, lightning round of questions, because there's just some, I don't want to call it bias, but I will. There's some bias in the way
absolutely
police officers and judges and juries evaluate these types of cases, these types being cycling cases. But let me save that for the lightning round because I want to talk about something that came up in my interview with John Gatch last week. John's very, very well-informed very strong cyclist and well-informed cyclist, comes from a family of lawyers. And we ended up getting into a discussion of home rule, which I may not have done enough justice in that interview. I'd like you to talk a little bit about what home rule is and how it applies in Ohio.
So home rule is enshrined in the Ohio Constitution, and Ohio is a home rule state, which basically means the state passes laws at the state level. But every city and every municipality and every village and every burg in Ohio can pass their own laws. There are certain things that are so important that uniformity is required. And there are certain things where you can have different laws for every city in the state. And home rule litigation evolves because somebody thinks that either that the city law is different from the state law and the state law ought to control, or the city law, or there ought to be the other way. There were two cases at the Supreme Court level fairly recently. One was the tow truck case, and it came out of Cleveland. And in that case, the court said that Cleveland could regulate tow trucks in addition to the state law, even though Cleveland laws were different. And then there was a case involving fracking, which is the drilling for oil in a particular way. And a municipality wanted to basically ban fracking. So they took the state laws and they added all these other impediments to fracking. And the court said, no, fracking is important enough that the state law controls. And so, the city won one, the state won one. And then this case came up in Dayton there hasn't been a case involving traffic laws, but in Kane versus City of Dayton, Mr. Kane was riding a bike in Dayton. And it's important that he was riding 30 minutes after sunset. And that's important because he didn't have a light on. And as he's riding on the right side of the road, I think he may have even been in a bike lane, a big, giant Dayton City fire truck came up from behind him, made a right turn, and crushed him, basically, as it was turning into a gas station. It was not an emergency situation. It's not like there was lights and siren. He was just going to get a milkshake at UDF or something and ran this guy over. So Kane sues the city of Dayton. And we find out that Ohio law says lights on at sunset. We all learned that as motorists. When the sun goes on sunset, you have to have light in your car have to be turned on. And that's the rule for bicycles throughout the state as well, which is what state law says. You have to turn your lights on at sunset. Well, in the city of Dayton, they passed a local ordinance that said you don't have to turn your lights on as a bicyclist until after sunset. So here he is, Mr. Kane, riding 30 minutes after sunset. He's in compliance with the city law that says you don't have to have your lights on until after sunset. And the city takes the position that even though we passed that law, we weren't allowed to do that because a home rule, under home rule, the traffic laws are so important that they have to be uniform throughout the state. And Mr. Kane said, wait a minute, you passed this law and I relied on it. I should be allowed to rely on the law that you passed when I sue you. And the city said, no, that law is no good.
Even though we
passed it, we weren't allowed to pass it. And so it has to fail. It's not constitutional under this home rule argument. And the court in that case did a really nice job of going through the multiple steps and that you have to go through to analyze a home rule case. And they said, the city's right, that traffic laws are of nature that they should be uniform throughout the states. You can't go through 10 cities and have 10 different rules about when you turn your lights on. Some say 30 minutes before sunset, some say an hour after, and now you're going to get, that it doesn't make sense. You have to have uniform rules for these things. And so Kane lost that argument, but it set a nice precedent because normally laws passed by cities don't benefit cyclists. Normally the laws passed in a city are meant to control cyclists, to ban them from the road, to mandate things that aren't required by state law. There's a city up in Northern Ohio that has a law on the books that says you're not allowed to ride two abreast. You have to ride single file, even though 451155B says cyclists may ride two abreast. They've just kind of sliced that out of the law, and there's signs on the road that say cyclists must ride single file. No one has challenged that yet, but I'm looking for a case. So I'd love to.
You're waiting for some renegade from Pickerton.
Yeah.
Is it Pickerton? Where is it up there?
Well, no, Pickerington had a similar law, but this is in Gates Mills, which is up near Cleveland.
All right. Well, if we have any renegades in Gates Mill, maybe get them out there and see if they can
do a breast ride.
Right. Get a group ride going. Get everybody ticketed. We'll represent you for free.
That's right. And it's it's funny how these things come up too, because there is if you ever Google the phrase safe riding regulations for bicycles, that phrase, you Google that and it comes up in 40 or 50 local ordinances for cities around the state. And I think a legal publishing company wrote a book of laws for cities, and you go to some little city and you say, gee, here's a book of laws. You can buy this book from us and you don't have to write all these laws yourself. You could just go through the book, pick the ones you like, change them a little bit, pass them, and you don't have to, create the wheel from scratch. Yeah. And inside that book, some guy wrote this safe riding regulations for bicycles. And there are all these stupid rules that say you're not allowed to ride on the road. You have to have a bell. You have to use the sidewalk if one is available. And all of these, I call it the stupid laws, got enshrined into local city ordinances. Then they're dotted all over the state. There's dozens of them. And up in Gates Mills, they have that. And there's several cities in that Cleveland area. There must have been a good sales rep up there, because you look at all of the 80 different cities in Cuyahoga County, probably 30 or 40 of them have these stupid laws. So they're out there. You got to fight them.
And the ammunition for fighting them is home rule. And in layman's terms, the test for home rule is if it's in conflict with Ohio traffic laws that applies to bikes, it would have to give way.
Right. Yeah. The test is traffic law is so important that there is a need for conformity. Kane says yes, there is. Kane is a trial court decision, and so maybe we need some appellate decisions in that regard. But yes, because the traffic laws are so important that you can't be changing them at the city level. You can't change state law at the city level, or else we're going to have all kinds of chaos on the roads. For what else can you change that would, you could change car requirements or turn signal requirements, or whatever. You can't do that at the city level. So that's the argument.
And the difficulty and kind of rectifying this situation is that there's a cost associated with it. You can fight a $150 traffic ticket with a $200 an hour lawyer, or just pay it and leave the books, leave it on the books instead of spending thousands of dollars getting it turned over.
Well, you get a ticket and it's not something, home rule is one of those esoteric lawyer things. They don't even teach in law school. If you practice in Ohio and you litigate certain types of cases, you learn about it. But most lawyers in Ohio wouldn't know what home rule is or apply to this situation. They would just say, oh, the local law says that. Well, then you're screwed.
You're stuck with it.
There's nothing you can do about that. Yeah.
And
lawyers and cyclists don't understand.
Yeah, the reality is it comes into play in personal injury cases where an insurance company doesn't want to pay because there's a violation of some local ordinance, whether or not it had an effect on the outcome of the crash. They're just not going to pay because the cyclist got cited.
Right. And that's what happened in my Pickerington case. I had a case up there where the law of Pickerington said, if there is a sidewalk next to the road, you're not allowed to use the road. You have to use the sidewalk. When my guy was on it was a basic residential, 25-mile-an-hour road. He's on riding his bike on there as he's allowed to do under state law. And he got rear-ended by a 90-year-old guy who couldn't see him, had a serious brain injury. And when I got the police report, it said, Mr. Cyclist, you were at fault because you were on the road, not on the sidewalk that was adjacent. So we had to, in that case, we didn't litigate through home rule. I managed to fix it by calling the city law director. And I said, look, you got a real problem here. I'm going to have to bring you into this suit. We're going to litigate this to no end because this is a case that, if the damages are big enough, it's worth going to the mat for this. And he said, hold on, don't do that. We'll fix the police report. And they issued a new report that said, even though local law says this, that local law is superseded by state law. And therefore, the motorist was at fault. So we were able to get around the problem without 5 years worth of litigation.
Yeah. And that's an example of a law director that, because of your intervention, realized he or she was on the losing end of a legal argument and didn't want to expend a lot of his or her time or staff time trying to defend a law that ultimately, at the end of the day, they know they're gonna lose on. Nobody likes to lose. You just give them
and it's a case where they probably would have to retain outside counsel to litigate it. So they're looking at thousands of dollars of money when somebody told them on day one, hey, you're going to lose this case. And they decided to fight it anyway. We're seeing more and more cities choosing the confrontational path on other types of issues these days, whether it's school board issues or whatever, and losing. And now all of a sudden the cities are coming up with having to come up with money to pay the lawyers and pay damages and all that kind of thing. That happened in the traffic camera cases quite a bit, where cities got the traffic cams and issued a bunch of tickets, collected millions of dollars, and then had to give it all back because the cameras were found to be either illegal or unconstitutional, or the system they set up for them was found to be bad. So that could be a problem.
I think the universal maxim there is money talks. And, it isn't goodwill and the benefit of their citizenry that legislators will and law directors will change their mind on things and say, oh, you got a point there. We ought to fix that.
Yep.
All right. One issue that comes up with some frequency in both our practices, but knowing that there's a lot of cyclists out there that use primarily bike paths for riding, or they're not always called bike paths, the multimodal paths or multi-use trails.
Multi-use path,
Yeah. So walk us through what happens when you exit a roadway and get on to a bike path, what changes in the standards there for proving it an accident, or excuse me, what burdens of proof in establishing why an accident
Right.
was someone's fault?
Well, so what we're talking about is a situation where you're riding your bike and somebody else does something stupid and hits you, knocks you off. They come around a corner too fast. They're in your lane. They pass you and sideswipe you, and you're now injured. If this happens on the roadway, all you have to do is to show that the other person was negligent or careless, which is a pretty easy standard to meet. And if that person was negligent or careless and hurt you, you win. And the only question is, what amount of money is the right amount of money to make you whole? If you ride your bike from your house on the road to the bike trail, that's if this car driver is careless and hits you, you win. If a cyclist that you're riding with tries to pass you and cuts you off and takes out your wheel and you go down, you have a claim against that cyclist for your injuries. Once your front wheels and rear touch the bike trail, that evaporates. And there is a new standard in place. And you have to prove that the person who hurt you was reckless or acted willfully or wantonly or intentionally, which is rare, but recklessness is the new standard. And recklessness is if you think about these standards as a ladder, at the very bottom, there's strict liability. If it happens, you win, basically. And then the next step up is negligence. You have to prove somebody was careless. Again, that's a pretty easy thing to prove. The next level is reckless. And that jump from careless to reckless doesn't mean intention. A lot worse behavior than simply being stupid or careless. There's an
really careless.
Or an element of understanding that what you're doing is a risky thing and you're taking a chance doing this. This isn't twiddling the dial on the radio and looking away and running something. This is you're saying, okay, that train is over there and I'm going to beat that train, and I know it's a risk, but I can do it. And all of a sudden you're going 80 miles an hour to try to beat the train and hit something. So reckless is a very difficult test, particularly on a bike trail where, most things that happen on a bike trail are carelessness. People aren't behaving recklessly. So I've had a number of bike trail cases. The only ones that are any good are cases involving dogs. And I've had a few of those where I had one where a dog was on a 10-foot retractable leash and the dog ran out. The cyclist tried to avoid and ends up going over the leash and gets injured. I had another one where the dog was well trained.
I just rode by, I was on the bike path for about 5 miles on Sunday morning. I rode past a guy who was riding his hybrid with his dog running next to him and the leash tied to his handlebars.
I see that more frequent than I would care to admit sometimes. But yeah, that seems a little reckless to me.
Yeah,
but
me too.
If the dog comes at you, he's going to drag that guy with him,
Yeah.
So it's under Ohio's dog law, that is one of the few personal injury areas where there is what we call strict liability. If the dog causes you to crash, the owner is liable. It doesn't matter how careful the owner was or how they may have the best chain, the best collar, the best fence, the best whatever. So he was hyper cautious and the dog still got out. If the dog gets out and the dog gives you injury, then you win. Whether it's at a road or on the bike trail, that's a case where you win. If the owner is riding towards you and, just goofs up and slams into you head on, you lose because you can't prove, unless you can prove that guy was driving recklessly, you're going to have a hard time getting over that hump. So you may have very bad injuries and no available recovery. So.
And it's important for the viewers to note that when you hear these dog statutes referred to as dog bite statutes, that's kind of their nomenclature or their shorthand. You don't have to be bitten by the dog to make a claim against a dog owner. The dog has to, the way both Ohio and Kentucky statutes are drafted, cause the injury. If they cause injury because they ran too close to you, or they ran up and knocked you off your bike but didn't bite you, the liability is automatic and strict. It doesn't have to be a dog bite. Now, if you get in a situation where they know the dog has a history of biting you, then you're into punitive damages and, a claim for some, at the end of the day, probably some personal assets, because insurance may not respond in that situation, may or may not. But that's an important distinction to be aware of. If you find yourself injured by a dog, don't be dissuaded by the fact that you've been told that Ohio has a dog bite statute or Kentucky has a dog bite statute. They're two different. The standard isn't bite. The standard is cause.
Right. And then some states do have a bite statute. Indiana has what we call bite rule, so that the first bite is basically free. The first time the dog does something, there's no liability, but now the owner is on notice. Right. So if the dog does it again, the owner has liability. That's not the law in Ohio. In Ohio, it doesn't matter if it's a puppy or an old dog or a frisky dog or a slow dog. A dog may just want to play with you. If they come out on the roadway, then the owner of the dog is liable to you for any damages that are caused. So most of the cases I've had involving dogs have not been bite cases. Most of them are the dog hits the bike, the dog gets in the way. A couple of them have been no contact whatsoever. The cyclist grabs the brakes to try to avoid hitting the dog and then tumbles over the handlebars and gets hurt. And the dog runs up and licks your face. Doesn't matter. The owner's still liable.
I had a dog. I was almost there on the receiving end of a dog bite in Kentucky. I was in a ride outside of Butler State Park, and I was bombing down a holler. And this was a long time ago, before I even had a Garmin that could route me home. So it was kind of an out and back on a vacation, out and back route. Got to the bottom of the hill, or before I got to the bottom of the hill, this white chow kind of runs up, hits the end of the driveway, takes a hard right turn, follows me menacingly all the way down the front, the property line, and then stops at that corner. So he makes this kind of shot to the corner of the driveway and then follows me to the other corner, making an L. So I'm thinking invisible fence, no big deal. So I'm coming back up this holler, and it's every bit of like an 8 to 10% grade. And I'm just huffing my way up, and I see the white chow, who's not very friendly in appearance. And I think I'm okay. It's an invisible fence. Well, he starts at that corner where he left me, and he runs and hits that corner at the driveway and then spills out into the road. And I'm thinking, like my number's up. And this dog got within, I don't know, maybe 4 or 5 inches of my heel. And I managed to pull away, but it was one of those adrenaline surges. I wish I knew what my watts were going up that hill. But by the time I got to the top, I kind of went into shock, because I had managed to stay away from this dog long enough to not get bitten. But all I could think about during that episode was that this guy's going to come out, see some skinny cyclist half-eaten in the roadway, and finish it off with a shot to the head and bury me in the backyard, and my family's not going to know any different as to what happened. But I managed to escape. Yeah. That would have obviously been if my family could have found my burial site, that would have been an actionable dog bite case. But
absolutely,
that's the closest. I've been chased by plenty of dogs, but that's the closest I ever came to actually getting bit by one. That was a.
I used to carry one of those little boat horns in the back pocket, and I had a few times where I had to pull that out, and if you give a shot of that, most dogs will turn and run in a heartbeat, because that's a mega decibel kind of event.
Right, and it's new
dog,
to them,
so.
Right? Because it's not something like, whoa, what is this guy?
That. Yeah.
Dog. So not only are you a bike lawyer, but you're a cycling dog defense expert.
Well, that's that worked. We used to carry water. I had a special water bottle with a little something in it that the dog would find irritating, or just squirting the dog sometimes. Just surprised by that enough, it gives you a few seconds to get an air horn. That was pretty. I hadn't thought about that angle, but that is a very, very good angle. If you're bike touring or something. They're only that big. They're only little canisters, and they've got that little horn on the front. But man, they put out some major decibels. So that's That's a
Yeah, I've never
blast.
thought much of
So
like
I've got,
bringing dog mace or bear mace. Those think that
yeah,
line
yeah,
is so narrow. It's like you've
yep,
got to be a
right,
marksman to scare that dog off with the mace.
right. Plus, if the wind is going the wrong way,
Yeah,
you're in
right.
trouble.
Got another problem entirely. Let
Well,
me move into one of my. Oh, go
oh,
ahead.
go ahead.
I'm stepping on your
No, I was
toes.
gonna say, we have two cases now. We have the fellow up in the Dayton area who had a dog encounter. He was ready to spray the dog and ended up not spraying the dog, but the owner saw that and then chased him down on a four-wheeler.
Yep.
And then brake checked him, so he ended up crashing. So we got that case, and I just settled a case in Athens County where a dog way out in the country, and a dog came out and actually bit my guy. And there were two of them actually, and he was able to knock one away and then got up the bike to fend off the other one. And we checked the Google map to find out where this place was. On the Google Street View, there's pictures of these dogs running loose. So
what are the chances of that?
Wasn't too hard to, it wasn't too hard to figure out where it was. So,
yeah, not everybody wants to fess up when it's their dog. That's another challenge representing injured cyclists. Like, I don't know what dog you're talking about.
Here's a brief war story. I had a kid who was bitten on the ear by a dog. Dog is his grandparents' dog, and the insurance company didn't want to pay anything, and the kid grew up and he became a model. I mean, he was in the Calvin Klein ad with the long hair and just very buff kid, but he had this ear that was chewed up by the dog, and part of the claim was, it kind of impacted his modeling career or whatever. And so grandma passes away. We had to actually sue grandpa. And we're in an arbitration, and grandpa's testifying. And I just, I thought he was going to be cooperative. And I said, so how long did you have the dog? It's not my dog. It was grandma's dog. So he refused to acknowledge that it was his dog.
You sued the wrong grandparent.
Well, the one who passed away, but he says it's grandma's dog.
That's convenient.
Like, okay. Yeah. Sorry, fella. But we ended up winning that. But it was one of those moments where you just kind of, I'm looking at the other lawyer and he just kind of going, hey, sorry.
Right. I don't know what to tell you.
There's nothing they can, you still win under Ohio law.
Yeah, he's still a
the
harbor.
Owner, keeper, harbor of the
right.
dog is liable. But
yeah, he thought he had you outfoxed. I mean,
he did. He thought he was smarter than me. He thought so.
And just for the benefit of the audience, we're a couple lawyers talking shop here. Under the Ohio statute, which is very similar to the Kentucky, there's these three standards of ownership. You can actually own the dog. That's the easiest one to establish. You can keep the dog, which is very typically the dog's been entrusted to you for a period of time because somebody's away on vacation. And then you can be a harborer of the dog. And that is where you acquiesce to the presence of the dog on your property. That sometimes is a landlord, sometimes it's a friend, sometimes it's a family member, but that catch-all harborer would capture grandpa when he's trying to lay it on grandma as the owner. It's a good story.
Sometimes we sign landlords because people renting a house, they don't have insurance, but the owner of the house has insurance. So if they've allowed the dog to be in there, we find an avenue to sneak into some insurance coverage. So that's where that becomes important.
There's always a fight with landlords because the legal standard is much higher than the strict liability of the dog owner. But you get a case, Steve and I handled one in Northern Kentucky with a cycling friend that ended up breaking his back going backside over tea kettle from a charging dog. And there wasn't enough homeowners insurance coverage, and we were able to tap some of the insurance coverage of the landlord. But it was a stretch of an argument because in Kentucky you have to basically occupy/own, but the standards occupy the premises as the landlord. So it's intended to capture only occupying landlords, not absentee landlords. But we argued that the properties were adjacent. You mowed the lawn, you maintained both properties. That's a form of occupation. The reason we're sharing that war story with you is that it's not a direct recovery against landlords, but any hook you can get into them to make an insurance company nervous is more dollars in an injured cyclist's pocket.
Right.
So let me.
Go ahead.
I was going to move on to my not so lightning round of questions if you're ready for them.
Sure, fire away.
All right. So I think you answered the first one. This is a straight up and down one. Do cyclists in Ohio have to use front and rear lights?
Cyclists in Ohio have to use front and rear lights when lights are required. So you can use them all day if you want. You're not required. Once dark sunset hits or the inclement weather would require you to have lights on your car, you have to have lights on your bike. You also have to have a rear red reflector. Front light has to be white, rear light has to be red. Rear light can be blinking. Front light doesn't say blinking under the law. A lot of people ride with front blinking lights. I've never had a case where the police have said you're not allowed to have a front white blinking light, but under the statute, it says specifically it's okay to have blinking rear light. It does not say specifically it's okay to have blinking front. So
yeah,
that's a long answer to the short question.
Do cyclists in Ohio have to wear reflective clothing at night?
No, there's no clothing requirement under Ohio law for cycling. There is a box in the standard Ohio crash report that says dark clothing, which is often checked. And then once that box gets checked, it gets reported in the media, oh, the cyclist was wearing dark clothing, as though that is some thing you're supposed to not do. But you can ride, in a jet black ninja outfit, and that's fine. There's no requirement that you have any special gear in Ohio.
Now, for the record, would not recommend doing that, especially at night. Because you'll get into a discernibility analysis under both Ohio and Kentucky law. And if you're not discernible, and the argument would be, well, I was discernible because I had my blinking red light on, but you will be subject not to any type of traffic violation, but an argument that you are less discernible than you could otherwise have been.
Right.
Fair statement.
I've spent days in court arguing over conspicuity, how conspicuous was something. And I have an expert out of Columbus who would testify on levels of conspicuity. So be as conspicuous as you can when you're out there. I think it's the bottom line.
Whether trying to be fashionable on a Friday or Saturday night or out on your bike.
That's right.
They're both the good rules to live by.
That's right.
Can you
conspicuous on life?
Can you listen to music with earphones on a bicycle in Ohio?
Yes, although there is a law that says headphones while you're driving a motor vehicle. That law does not say vehicle, it says motor vehicle, and bicycles are not motor vehicles. So in theory, you could lawfully ride with headphones on like these or like yours or whatever on a bike. It's not recommended, and it's going to get written into the police report if there's a crash, and it's going to be more difficult to move forward, but the law does not ban you. The law doesn't say you're not allowed to do that.
Right. So. Yeah, if you're in an accident when you're wearing earphones, you're going to hear about it from defense counsel or the insurance company if it's a claim made pre-suit. And the argument would be that you were contributory negligent. I don't think they could argue with a straight face. You caused the accident because of your earphones, but you're going to have to take a haircut on the value of the case because of the argument that somehow it impacted the overall dynamics of the accident. Okay. E-bikes are becoming even more popular. In fact, I should have looked this statistic up. I think it's higher than 40 or 45% of all new bikes purchased in Europe are e-bikes. And currently it's something like 10 or 15% in Ohio. So 10 or 15% stateside. So talk to me about e-bikes under Ohio law. Are they bikes, and how are they handled?
Yeah, e-bikes, Ohio has bicycles, electric bicycles, motorized bicycles, and mopeds. And e-bikes, before the statute was added a couple of years ago, e-bikes were this weird thing because they have a motor, but the laws relating to mopeds and motorized bicycles talk about motors that have piston displacement and horsepower, and e-bikes are electric motors that don't really fit into that paradigm. And nationally, the e-bike people put together a model law that they pitched to all 50 states, and Ohio bought into it, as did many states. So now we have 3 classes of e-bikes, which are, and if your bike meets that definition, then you are lawfully allowed to ride that on the roads. There are the first class, class 1, is an e-bike that has a up to 750 watt motor, and it only works while you're pedaling. It won't shove you down the road like a motorcycle, motor scooter, but while you're pedaling, it'll push you along up to 20 miles an hour. Class 2, same thing, 750 watt motor, but it will push you along without pedaling. So you can coast and go 20 miles an hour. Class 3 is like class 1. You have to be pedaling, but it'll kick it up to 28 miles an hour. And what Ohio law says is that you can ride class 1 or class 2 e-bikes on any trail, any bike trail, unless the trail owner decides they don't want you, and then they can kick you off. Class 3, the general rule is you're not allowed to ride them on a trail unless the trail owner lets you ride. I don't know how a cop is supposed to look at a bike and know what it is, how
many watts it's capable of generating.
Yeah, well, but some of them are tuned to go faster, and so unless they stop you and they see the class 3 sticker, it's hard, or you're going 35 miles an hour maybe on it because you're pedaling plus the assist. But the class 3, you have to be 16 to ride them. You have to have a helmet, which is the only set of bikes in Ohio, I think, where you have to have a helmet. So there's some little differences for the class 3 bikes, but there are also these kits you can buy on eBay or elsewhere where you can slap it onto your bike, and all of a sudden you can go 45 on your bike, and that is an illegal vehicle, and it can be taken from you for, at least if they catch you with it, you can be charged for under not having a license. And I had a fellow who had lost his license on a DUI and then built one of these do-it-yourself e-bikes, and he got stopped by the state troopers and was facing potential violations of his license suspension because he was driving what is now a motor vehicle because it has a big motor on it, and driving it unlawfully. So I had to refer him to criminal counsel because he was looking at some problematic time there. So
he was trying to end run his probation
that's right,
in
his
the eyes of the
suspension.
state.
And you can buy those motors pretty cheap. They're a lot cheaper than an e-bike, and if you know what you're doing, you can hook them up yourself. But the risk is, A, you're going to get stuck like he did, and B, if you're in a wreck or something, you're not going to be able to win because you're driving an illegal vehicle. So
remind me the wattage or standard on the class 3s where you have to wear a helmet.
It's a 750 watts, but the way it's tuned, it'll push you to 28 miles an hour.
Oh, okay. So that's
the kicker.
Yeah, I don't know how
top speed goes up from 20 to 28.
I don't know how a police officer would charge somebody like that other than looking up the standards online for a particular manufacturer.
Each bike, under the law, each bike is required to have a sticker on it that tells you what class it is. So in theory, if you haven't removed that, there ought to be a class 3 e-bike sticker on the bike somewhere.
Gotcha.
And you would know that? I mean, if there's a line of bikes going by, you would never know which one was a class 3, which was a 2, which was a 1. So as long as they're all pedaling. So.
Gotcha. Okay.
Class 3 guy would be sweating a lot less because he's got a bigger motor going.
He's the guy that's the freshest on the last climb of the ride.
Or the most tired because now he's pushing a
pound
bike up the hill because he
ran out of
juice on the way home.
Yeah. Right. His just desserts. Okay. Here are some, I guess I'd call them practical problems. This may devolve into a panel discussion between the two of us, but let me ask you an obvious question. Do bike cameras help?
Oh my gosh, yeah. Bike cameras are a game changer. in every case that I've handled, I would say, involving a cyclist, there are factual disputes where the cyclist says, I was doing this, and the motorist says, you weren't doing that, you were doing something else. And the camera, makes it very clear what was happening. It provides, the visual evidence that you would want. I had an early case. I had a guy who had a helmet camera mounted. He was at the bottom of a hill. The light changes. He goes up the hill in Clifton. He gets rear-ended, knocked to the ground, and you see the camera go down. His head bounces off the pavement a couple times. He gets up, looks around. Here's his bike under the car. He goes over, sits down under a tree. And I got the case. He was a friend of mine, and I notified the insurance company, and the insurance company says, well, we talked to our driver, and our driver says your client just came out of nowhere in front of him. And I said, have you seen the video? And she said, what video? And so I sent her the video, and it's clear the guy's going in a straight line up the hill for 17 seconds and then gets clobbered from behind. So he didn't come from nowhere. He was in the middle of the lane, and he got hit. But had he not had that, we might have had some issues with him arguing. Maybe he was off to the right and then came over to make a left turn, or who knows what. But the camera made it perfectly clear exactly what happened in that case.
Now, you've been at this a little bit longer than I have, but in the years that I've been doing it, I have yet to have except one case, and I was defending it. I've yet to have a case where a driver admits that it was their fault that they struck a cyclist. What's your batting average in that regard?
Probably better than that, but there's always some argument or excuse or something. Somebody comes up, like I said, the suicide swerve where there's a pass, and they say the cyclist, dove into the side of my car as I was going by, or they made that movement or whatever. Or even in a dooring case that I had where the cyclist was just the only thing on the road, and the lady opened the car door, hooked the handlebar. The cyclist went over the handlebars and suffered a pretty bad injury. The lady said the argument from the lawyer was the cyclist had a duty to not ride that close to the car, just in case somebody opened their car door and tried to hook you. And it's like, that's not what the law is. You don't have to, we don't
right.
drive our cars with the expectation that people are going to do stupid things in front of us. The whole point of having the right of way is you're allowed to go down the road with the right of way, assume that everybody else is going to stay out of your way. So, that comes up, something comes up in every case where there's some argument that we did something wrong. So
yeah, and that's
why
these are obvious. Yeah, these are obvious observations, but when you're recording it in real time, it takes all the after the fact machinations out of debate. It takes it off the table. You can't debate it. And I mean, we've both seen it. We're not young men anymore. Where we went from no cameras to the availability of relatively inexpensive cameras, and that goes for.
And if you're riding a lot, that's what you should be doing.
Yeah, and it also goes for the footage in and about the accident scene, because the longer you wait, and I'm just shamelessly plugging our services, the longer you wait to retain an attorney, the higher the likelihood is that third-party footage is going to be deleted or taped over. So the idea is, sooner you retain counsel after the accident, we perform that investigation. And there are, more often than you'd think, cameras in and about intersections and on roadways and on apartment complexes that catch accidents. I have one right now where involved a brain bleed, where my guy was run down from behind, and it wasn't his camera footage. It was the camera footage of security footage about 100 yards down the road that established that my guy. Okay, the allegation was my client was in the left lane, and he got run down in the left lane, and the argument is he should have been riding as far right as practical. Footage shows him going uphill on the far right riding as far right as practicable. And this old man straddling the lane as he took a hard left turn, accelerating as he goes off scene, so that it doesn't pick up the accident, but it picks up the 7 seconds before the accident, showing my guy for 30 seconds in the far right lane, and the motorist straddling the left and right lanes, and 5 seconds later, 7 seconds later, depending on how you count it, running my guy down from behind. Other than shamelessly plugging, the two of us, it speaks to the importance of on deck camera, meaning on the bike, or third party video to keep everybody honest about what happened, because the defendant in my case is just swearing on a stack of Bibles that it was a suicide swerve and it was my guy's fault. And we hear that more often than we care to admit, that these cyclists just randomly swerve in front of cars almost as if they had a suicide wish, hence the term suicide swerve. So moving off of cameras and talking about cycling computers. Why are cycling computers so important to an attorney reconstructing a bicycle accident case?
Sure. Yeah. Well, cycling computers and phones, any device that retains data that you're using. And that's the important part. If it's a cycling computer is just telling you how fast you're going, but it's not retaining that data. Like I have an old cat eye, and it'll tell me what my maximum speed was and how fast I was going, but it doesn't map my ride or do anything else fancy like that. But if you have an iPhone and you have a GPS built into the iPhone, and it's probably, unless you've turned it off turn that file off, that iPhone is figuring out where you went, where it's pinging and all of that, what roads you're on, in case, you have Auntie Annie's pretzel app and the iPhone wants to let you know when you're close to Auntie Annie. So it tracks where you are. And when you get close, it sends you a message that, hey, you're almost to Auntie Annie's. Why don't you get a pretzel? The way it does that is that it creates a GPS file within the phone. Same thing with the GPS cycling computer. Even though it's mapping out a ride and all that, it is actually retaining thousands of data points. And each data point tells you where you are on the earth, what direction you're heading, how fast you're going, how long it's been between the last time it took a data point. So it's like constantly taking these snapshots of you. And it says you're at this point, this point, this point, and each point it gives you a spreadsheet of data for each point that it takes that picture. And we can then extract that from your device and use the data in there to tell the other side how fast you were going, where you were going, what direction you were heading, what lane you were in, although the accuracy of the GPS makes that kind of difficult because it's like plus or minus 10 feet. So you might be in this lane, you might be in that lane, but so that amount of precision generally isn't there. But for example, in a case we had, it was a death case. We had 5 cyclists coming down a hill going 30 to 35 miles an hour. They're going due east. A big pickup truck is coming towards them and is going to turn in front of them onto a road. As the cyclists are coming into the intersection, the truck makes its turn and he hits the first 2 riders and kills them. Then the next 3 plow into the truck. The truck driver says, "Oh, the sun was in my eyes. I couldn't see anybody." And his expert said that the cyclist didn't make any effort to slow down or avoid the crash, like they had some duty to do that, which they didn't. But when we got the Garmin from the lead rider, who's my client, the Garmin shows coming down the hill, going due east, 35, 30. And then there, within a second before the crash or so, there was a sudden slowdown in the speed and a change of direction. So there's the Garmin shows him slowing and going to the right. Our argument was because he perceived that big giant truck moving and he tried to go to the right, but then got hit before he could get around the truck and got hit by the corner of the truck and was killed. So we had a good argument based on the Garmin data that our client's husband, who was killed, did try to take
evasive
action. It was
action.
not just
Yeah.
blind. Yeah, it was not just trying to blast through the intersection, but actually pulled to the right, slowed down, and still was hit by the big truck. So we can, once we can use it for a number of things. I had a second case where the cyclist came up to a road and made a right turn, and then went for about 20 seconds, and then was going to make a U-turn and go back the other way. And then a motorcyclist came up behind the cyclist and tried to pass him as he was making the U-turn, and they collided and hit. And the GPS, the guy was riding a very fast triathlon bike with the, with the aero bars and the whole bit, but the GPS shows him going 7 or 8 or 9 or 10 miles an hour and slowly moving left to right, which conformed with his testimony, because he said he decided to do that. He looked back, he didn't see anybody, he put his arm out, moved slowly to the left, and then he was hit at the last minute by the motorcyclist who came up, pretty fast from behind him. So we're able to show there was 20 seconds that he was on that road. Everything he did should have been visible to anybody coming up from behind him, and that passing him at that point was a stupid thing to do. That was our argument anyway. So.
Yeah. And the thing to be aware of with regard to at least head units, not iPhones or Androids. The big two are Garmin, obviously Garmin, and Wahoo. Karu's making some inroads, but they have their own proprietary sampling rates and offsets from GPS satellites. So just so the viewers are clear on this, the GPS data is not gospel. It needs to be corrected typically by an expert so it's harmonized with the error. It's not really an error rate, it's a set off rate. I don't know if it has something to do with commercial satellites or not being able to have them commandeered by bad guys to bomb Americans, but regardless, they all have an offset, but they're not uniform, and they also don't have a uniform sampling rate. The sampling rate is uniform, but it's not uniform from manufacturer to manufacturer. So all that data needs to be corrected or cleaned up, scrubbed by an expert before it can be used in trial. Not a difficult task to do, but it's a game changer in the sense that absent you can correct me, Steve, on this point, absent the direction of, I'll call it deformity of a wheel, you can deduce a lot about an impact with regard to how a wheel tacos or gets deformed. But outside of that piece of physical forensic evidence, it can be a difficult task recreating a bicycle accident case because they don't have the traditional skid marks or just the size of, most of the vehicle is the person. They don't have the same size as a vehicle to show the nature of the impact and from which direction it came. Is that a fair statement? Or
yeah, I think that's fair. Yeah, and when you're talking about correcting GPS, in that case I talked about with the 20 seconds, the GPS stayed on the bike.
You just lost me.
Battery.
Hold on, I got to change the battery. Take a short commercial break. I'll edit this out. All right.
Hey, you're back. All right.
All right. The beauty of editing, the beauty of editing after the fact. So just to reset the stage here, rookie podcasters, camera battery died. And when we died, we were talking about the GPS data that was collected on your U-turn case, and
right.
kind of cut out at the U-turn portion.
Yeah. So what happens is the guy makes the U-turn, gets hit by the motorcycle, the bike goes off to the side, and it sits still in one place for a while. And when we looked at the GPS, the GPS points were kind of scattered all over the place. And the expert that we had said that that's because it was probably getting data from different satellites at different times, which because of the plus or minus 10 feet, sort of a 10-foot diameter circle that it thinks this bike is in, but the precise points may depend on refraction or whatever. I mean, there's a lot of different things that can come into it. So there isn't quite the level of precision with regard to lane placement, but things relating to speed and time and distance are extremely precise.
And orientation too.
Yeah, and orientation as to which direction you're going. So in the first case, because this road was east-west, I mean, due east-west, and so due east is like 90 on the thing, and due west would be, 270 or whatever. And so we went from 90 to like to the right. We could tell he was going to the right, trying to get around this vehicle. So that part of it is very accurate. Whereas whether the lane position may not be as accurate because of the distance.
Right. Cautionary tales.
All that data is extremely,
Better to have it than not have it.
It's very useful in the right case.
All right, let me conclude my not so lightning round list of questions here with maybe an observation on your end. If you could talk to us about the practical problems of what do we want to call it? I'm coining a phrase off the top of my head here, kind of motor vehicle operator bias that comes into jury pools and judges who are deciding cases.
Right.
And how do you handle that, and how do you prepare your clients for that reality?
Well, if you're in litigation and you're looking at trying a bicycle case, you can start on day one, hopefully prepping the client for the fact that not everybody rides a bike, and I would say the majority of the people you're going to get in a jury, particularly in certain jurisdictions, are going to be people who are very adverse to. So we have to plan on getting very basic questions into evidence about riding a bike and what you're doing, and establish very clearly. And sometimes we'll do that through motions where we can ask the judge to order as a matter of law that the client had a right to ride on the road, and had a right to ride on this road, and was riding lawfully on this road at the time they were struck. And so all those things are not coming from me, they're coming from the judge in an order to the jury to say, I'm ordering you to take these things into account. We also try to find out through jury where we get to actually talk to the jurors, and sometimes they just people don't understand that you're allowed to ride bikes on the road.
Yeah.
Some people think that if you were to allow bikes to ride on the road, then people would be killed left and right, and they're surprised to find out it's actually pretty rare that these crashes happen and fatalities happen. There's millions and millions of people that ride bikes in the US, millions, probably at least 1 million or more in Ohio alone, that ride bikes and ride at some point on the road. And we'll have 1,500 crashes that are statistically found each year, and 16 or 17 people are killed in Ohio each year. Those are small numbers, meaning cycling is generally a very safe activity. We try to emphasize that, and then you're focusing on the stupid, careless thing that somebody else did to hurt the client, everything right, and hopefully, and the idiocy and the reason this crash happened is because somebody else violated some very basic safety rules. If we all follow the safety rules, nobody gets hurt. We learned that in kindergarten. And too often, the motorists on the other side of these cases do something stupid, and as a result, they end up hurting somebody, and that's the focus.
Yeah, the you may have cut out with your internet connection there. There's a so the viewers are clear. There is a time in a case called voir dire, another one of those Latin words, Latin phrases, where you're allowed to ask prospective jurors about their biases or their inclinations or beliefs about a certain topic before they get impaneled onto the jury. And at that stage, the judge may kick somebody off for cause. That's very rare, but you can exercise what are called preemptory challenges to narrow that jury pool to the best of your ability down to a group of 8, or depending on your jurisdiction, maybe more of your peers that are going to evaluate your case. And there's just there's a lot of teasing out of bias that goes on. No one likes to think they're biased, right? No one wants to be prejudiced, but there's a bias people bring to the courtroom. And if they're unfriendly to cyclists or have a belief that cyclists should only ride on the sidewalk if I only had a nickel, or why aren't they just staying on bike paths? Why would you even ride your bike in the first place? I don't understand why you'd even put yourself in peril.
Right.
You're dealing with folks that have that kind of worldview, and that's not a narrow subset of America. That stuff you got to break down before you try the case. So you've got 2 opportunities, maybe more, but two basic opportunities to deal with that. One is at voir dire, and then the second is what, like you discussed, having the judge instruct the jury about what the law is and that they're obligated as a matter of law, as part of their civic duty as a juror, to apply the law. And then you turn it, and at least in my experience, is as best you can, into a KISS situation where you just keep it simple, stupid. This accident wouldn't have happened but for the other side's negligence. And at the end of the day, all they're trying to do is deflect their own responsibility by trying to blame it all on the cyclist. And then you have a little bit of a kind of a gang up on the little guy mentality that maybe has some jury appeal, but there's no guarantee in that regard.
Right. Well, and that's another reason why, as advocates, I like to say my 9-to-5 job is representing cyclists, and my 5-to-9 job is working on the advocacy side of this. And that sometimes that means writing things for people to read or speaking at different events. And I've been sort of the spokesperson for the cycling community here in the last several years. And we try to improve the public's awareness that A, we're out there, B, we have a right to be out there. We're not going anywhere. We've been out there since the 1880s, and we've been lawfully using the roads for many years. And we try to overcome some of the bias and also address some of the common things that people say. Well, you don't pay taxes. Well, yes, we do. And people think there's some road tax that everybody pays that gives car drivers the right to use the roads. And the counter to that is, A, there is no such tax. B, we all pay taxes. Most bike riders pay a ton of taxes for a variety of things into the general fund that runs the roads. But roads are public ways. They're things created for the public to benefit the public, and you can use roads with any variety of vehicles, including horses if you need to on some roads. The Amish, buggies, bicycles, cars, trucks, buses are not the only thing permitted on the roads. People are surprised to learn that, but sometimes we have to kind of really work to make that point out in public as advocates for cycling as well. It's a lot of education is needed.
Yep. We're on a constant PR campaign when we're out there interacting with the public as well on our bicycles, and sometimes you have to bite your tongue for fear of not for fear of, but at the risk of tainting a potential jury pool. At least that's what I remind myself when I.
Right.
I'll end with one story here. I was out on a ride, same ride I was telling you about before, on a Sunday, and we were kind of cutting through a neighborhood because a road was shut down, and I went on one side of the sidewalk to give this nice old lady plenty of room to pass or to get around her because she was walking her dog. And my buddy was on the left side trying to give her as much room, but not get caught up on the dog because the dog was on her left side, my right side. And as we're riding away, this old woman starts barking at us about which side of the sidewalk are you supposed to ride on? I'm thinking to myself, well,
thanks, lady.
we really weren't riding on the sidewalk. It was about literally, I'm not exaggerating, about a 20-foot little cut through. And I turned to my riding buddy and I said, you know what, she could be a juror someday. And you wouldn't
That's
know any
right.
better. You think this nice old lady walking her dog would be somebody
Yeah.
you'd want on your jury. And she started grousing at my riding mate about riding on the wrong side of a sidewalk that he wasn't even on because he was on the grass, but
Right.
whatever. She was just irritated we were out there. So anyway,
Well, that's what we run across. People are irritated that we're out there. And I think when you look at 2020, people got really used to driving around with not a lot of traffic. And so
Yes.
2020 speeds were up and motoring itself was way down, but the people who were out there got to go really fast and they could get around easily and there wasn't a lot of people on the roads. And now their traffic is back up. Bike riding got very popular in 2020 as
Yeah.
well as some people could do. And they sold a lot of bikes. They couldn't keep bikes in stock in 2020. And so now there's a
Still
lot of
struggle
new
with it.
riders, a lot of people on bikes. Yeah, a lot of new traffic users and on the roadway and a lot of motorist cyclist tension is out there. We've been hearing about more aggressive anti-cycling behavior by motorists in the past 12, 15 months or so. So be careful out there.
That's right. Well, Steve, thanks
And
for
call
your
us.
your time. Yeah, call us for sure. You know where to find us.
Yeah,
Our
right.
contact information is directly below each one of our talking heads here. Thank you for taking the time out of your schedule, especially
Oh,
during
yeah.
Bike Month, to illuminate us on cycling issues in Ohio. And thank you for all your advocacy.
Oh, well, I'm very happy to come and talk bike anytime. You can always ring me up for that.
All right. Take care. I'm signing off.
Thanks.
All
Thanks.
right. You can hang on. I'll stop the recording.